Namaskar. Let's begin with the Patent Act. So, the first section talks about sort, title, extent, and commencement. We will stick to the exam preparation, and as far as exam preparation is concerned, what we need to remember from this section. So, this act is called the Patent Act 1970. So, as the date itself suggests, it commenced on 1970, and this act is beautifully written by Techchand sir and Iyengar sir. So there are two committees, Techchand committee and Iyengar committee, and who drafted such beautiful act. Second point is it extends to whole of India. It means if you file a patent and once it becomes your property, this is called intellectual property. So that property is for the territory of India. So you are not having any rights out of India if you are not filed it in outside. So basically, it's a territorial right. That's what it wants to convey. The third thing is it shall come into force on such date as the central government may, by notification in the official gazette, appoint. So this particular act is published through official gazette, that is published by central government, and then it is called applicable to all of India on the date on which it is published by central government in the official gazette, provided that the different dates may be appointed for different provision of this act. So this particular act is approved by parliament, and the rules of it that approved by central government. Now act suggests what kind of action to be taken, and the rules suggest at which time and by filing which form and with which timeline it has to be happen, and that rules are governed by, or say it is modified or amended by, central government, while this act can be approved by or modified by or amended by parliament. So that's what it suggests. So that's it. Only 3 point. Number one, this is called Patent Act 1970. So its commencement is from 1970. Second point, it's a territorial right. If you file application in India and if it is granted, then you will have a rights in the Indian territory itself. And the third point, the act is approved by parliament, and these rules are approved by central government. So these 3 points that you need to remember from the section 1. Now let's begin to the section 2 then. In the section 2, the first definition is for the appellate board. Now what is appellate board? Right now appellate board is not available, or it is demolished since 2021. But yes, instead of appellate board, whatever activities are held in the appellate board, right now those activities are held in the IPD section, Intellectual Property Division section at High Court. So why this appellate board is constituted? So it is constructed for the purpose to appeal something. That name itself suggests appellate court. But what to appeal? To appeal any injustice done by controller. So the highest authority in the patent office is controller, but he is also a human being. So sometimes it may possible that some wrong decision taken by the controller, and controller is the supreme authority in the patent office. So how to deal with any injustice occurred by the controller? For that purpose, appellate board is constructed. And now that appellate board's work is done by the IPD division at High Court. I have already submitted to you a detailed difference between the IPD and the appellate board. So please go through the documents, not for the purpose of examination, but for your knowledge enhancement, so that you can identify what kind of actions to be taken by the IPD section at High Court. Second definition, subsection A B ground, is assignee. Let's suppose you are the owner of a patent and you want to assign that patent to someone else, to your daughter, to your son, to your wife, to your husband. So it is very much possible by assignee rights, correct? So assignee is nothing but to assign something on behalf of the actual ownership. ABA ground, Budapest Treaty. This particular treaty talks about microorganism and how that microorganisms is inserted into the patent. Many a times, the biological material or microorganisms are used in the invention, and that particular microorganism need to be submitted to the International Depository Authority, and its reference has to be mentioned in the application. So with which timeline and by which procedure it has to be submitted, that is detailed information provided under the Budapest Treaty. So Budapest Treaty is constructed for that purpose only. Next definition is AC ground. Now, in order to remember this particular AC ground, reverse it. It means CA, capable of industrial application. C stands for capable and A stands for application. An intermediate part is industrial application. That is one of the condition from the patentability criteria. There are total three conditions. One is innovation, second one is inventive step, and third one is industrial applicability. So this is third condition of the patentability criteria, which is capable of industrial application. Now, what does this means? It simply means either the article which is formed by the patent, it must either used by the industry or made by the industry. It's connected with the or condition, means any of them will work, either used or made by the industry. If that article is used by the industry, it serves the purpose of capable of industrial application. If it is used by the industry, it also serves the purpose of the capable of industrial application. Next definition is controller. The controller is defined under section 73 of the Indian Patent Act 1970, and it's the supreme authority of patent office. Next is convention application. In order to file application outside India, there is one convention treaty followed by the many convention countries. It is called Paris Convention. And as per the Paris Convention, if some person of any of the convention countries wants to file application in another convention country, then there is a period of 12 months is provided so that a person can file convention application. With an example, suppose today you have filed an application in India, and if you want to file an application outside India, so you are having a time of 12 months in order to file it through convention route. And in the similar manner, if the other country is also a part of the convention country, India is a part of a convention country, and other country is also a part of a convention country. So Mr. John, who has filed an application in USA by today, so he can file an application in India through convention route within 12 months. And convention application defines under section number 135 of the Patent Act. Now the next point is convention country. As I have already defined to you, convention country is a group of country which are bound with the bilateral agreements. What does it means? Suppose any person from the another convention country, as an example, from the USA, if someone files an application in India, so that person is treated like an Indian person is treated in order to file application in India. In the similar manner, when some person from India is filing an application outside India, so that Indian person also treated as it is as he or she is a citizen of that country. So this is called tit for tat condition. Sometimes it is called reciprocity. And from that perspective, convention countries are group of countries which are clubbed together to give a same kind of treatment as they are giving to their own citizen in order to promote inventions. And convention countries are defined under section 133 of the Indian Patent Act. Next point is district court, where CPCs are applicable, Civil Code of Conduct. That court is district court. And next, section 21F definition is exclusive license. So patent is an exclusive license given to any citizen or any resident of India by the central government of India. So what does it means? Once central government is giving an exclusive license for the period of 20 years, so it excludes central government itself. It means now, if central government is not following the direction of the Patent Act after giving exclusive license, so central government also treated as a person who is infringing the patent rights. And in the similar manner, if a patentee is giving exclusive license to someone else, so it exclude himself as well. G is omitted. H, government undertaking. Let's suppose in order to derive your invention, you have communicated it with the government in order to get a grant from the government or for various purposes, like if you are deriving any invention in automobile, then you are dealing with the ARAI for certain certifications, Automobile Research Institution for certain certifications. So before deriving any invention, you have to follow certain procedures. And in that procedures, you have communicated your invention to the central government. So that particular declarations to the central government or any government companies, not only the central government, but any government countries which are either fully or partially part of the government. So that declaration is called government undertaking. High Court. In some of the places like Australia, the High Court is the ultimate court. But in India, we are having three levels of court, from starting from district court, then High Court, then Supreme Court. International application. The application which is filed through PCT route, Patent Cooperation Treaty route. It is called international application. The main difference between the convention countries and PCT application, or say international application, is the application which is filed through conventional route. It is called convention application and it has to be filed within 12 months. While the international application is also an application which can be filed outside India, but the international application is allowing us to give such platform through which one can file outside India application within 30 to 31 months, provided that once that Indian person is filing first application in India, then that Indian person is filing international application within 12 months from filing an application in India. And when it designating, say, any n number of countries, let's suppose USA, China, and Russia, where one wants to file a protection, when one wants to desire a protection, so that particular countries in that particular national, the national phase entries can be derived till 30 or 31 month, depending upon the norms of that countries. In India, if suppose any conventional countries person coming through PCT route, so we are allowing that person to file within 31 months from the priority date. Invention. Now, what is invention? See, invention is having two criteria. One, either it should be product or it should be process. Either a new product or new process. Also, it incorporate inventive step plus industrial applicability. So when this two criteria matches, one is either product or process and having inventive step plus industrial applicability, then it is called invention. So now curiosity will arise, what is inventive step? Because industrial applicability that we have already derived here, either used or made in industry. So what is inventive step? The inventive step is the step which either having technically advancement, either technically advanced or economically significant, or both. Means any one of this condition has to be satisfied, and it is non-obvious to the person's skill in the art. So it has to be something non-obviousness into it. It not should be an obvious one. So one can easily predict it and one can easily reproduce it by using their common sense, by using the already literature available inside the public domain. It has to have some non-obviousness into it, and also having one of the criteria, either technically advanced or economically significant, or both. Either it should be cheaper one or upgradation of something. So that is called inventive step. And when this inventive step is combined with the industrial applicability, then it is called invention. Next point, legal representative. A person who is taking the state of any deceased person, that is called legal representative. So after my death, my legal successor is my son or my daughter or my wife as per my will. So that is called legal representative of any deceased person. New invention. New invention means which is not available in the public domain so far. So far means before the date of filing. It should not be present anywhere in the world in any document, either patented or non-patented literature. Next definition is opposition board. Opposition means not only the controller who is restricting any application in Patent Act, but also any interested person or any person can take an objection, or it should be an opposition, which will be defined under section number 21. Sorry, 25. So section 25 talks about the grounds which are available to take opposition of any application. And based on these grounds, not only the controller, but any person can take opposition. Opposition means can suggest whether that particular invention which is filed that having a potential to explore or not, that having potential to become property or not, that having potential to become patent or not. Patent, an application which is granted, then it becomes patent. Patent agent is a person who is having a knowledge of Indian Patent Act and rules and able to give you the judgment or able to give you the uh, highlights of the forecast of the process as per the Patent Act for the given property. Patented article, an article which is prepared through the prescribed manner suggested by the Patent Act and rules, that is called patented article. PCT application, an application which is filed through Patent Cooperation Treaty, that the application which I have already talked to you, which can have a national phase entry within 30 or 31 months, that is called PCT. Patentee, a person who is filing an application of a patent is called applicant. Once that application is granted, then that person becomes patentee. Patent of addition, It is defined under section number 54, but by and large, what is patent of addition? Suppose you are filing an invention, you are a researcher, and during your research, you are come to know that this is an invention, let's file a patent of it. So you filed an application, and now you realize there are further chances of research gap, and further research continues, and you find out a mere arrangement or rearrangement or something like that, mere improvement through which the existing patent can be optimized. So that particular improvement is filed after filing in patent of application as a patent of addition. Patent office, there are four patent office in India. Which are those? Google it out and also mention your jurisdiction in the comment box and message me personally. So patent office under which the patent uh, prosecutions is held. The complete process from the application phase till the grant of a patent is carried out. That is called patent office. A person. A person is any person, including government as well. Person interested. A person who is closely in relation with the invention, either in terms of research in the same field or promotion or in marketing of the same kind of invention, that is called person interested as far as this patent act is concerned. Why we are learning these definitions? Because this definition will have their impact while learning about the patent act. So whenever this person interested is written in the patent act, it means either that person is in the research of the same technical field of the invention, or it is or he or she is in the promotion or in the marketing of the same kind of invention. Pharmaceutical substance related to pharmacy domain, the ester forms and uh, the active pharmaceutical ingredients are comes under the pharmaceutical substance. Prescribed as prescribed in the patent act. Prescribed manner, the manner with which it is prescribed, means within which time it has to be filed, by using which form it has to be filed. That is called prescribed manner. Priority date, the date on which the application is filed for the first time in any country, that is called priority date of that application. Register, and register is maintained for two purposes, one for the patent application, another for the patent agent. So e-register of the patent application gives you the information about the patent granted, and the register for the patent agent gives you the information of registered patent agents. True and first inventor. True and first inventor definition defines under the Patent Act is like the person who is importing a product from the outside first time, he is not a true and first inventor, or the person who is selling the product first time outside India, he is also not a true and first inventor. So that's it from the section 2. Let's begin with the section 3 then. Section 3 talks about what are not an invention. If it is not an invention, the application is not at all patentable. Correct? So what are not an invention? The first one, the first ground, there are A to P ground of it, and this section has to be remembered as it is. Correct? So first grounds talks about natural laws. So those invention which are not following the natural laws are not patentable. Correct? Example of it. Suppose someone is Suppose you are patent agent and someone comes with an idea that, sir, madam, I prepared an engine which are having more than 100% efficiency. Is it possible? No, it is not possible. Why? Because it is against the natural law. Natural law suggests that there is always irreversibility due to friction and backlashes, wear and tear, friction and wear and tear. So that's why natural law suggests there is no machine which can give you the efficiency more than 100%. Even 100% is also not possible. So if such kind of invention comes to you, you can directly suggest them, sir, it is against section 3A ground, so it is not patentable. B ground, prejudice or against the public morality. Suppose a person came to you with an invention which defines how to do malpractices, like uh, a thief come with a knife through which it is very easy to do thief kind of activities. So that is against the public morality and it is not at all patentable. So how it is helpful to the society, that has to be governed by the invention. If it is against the society, then it is not at all invention. Ground C, discovery. Suppose the Newton Baba born today in 2025 and the discovery of gravitational forces is not yet discovered. And that Newton Baba is sitting below the tree, an apple comes down and he defines or he find out a gravitational force. So Newton Baba came to you and says, hello, sir, I found this particular equation of gravity. Is it patentable? So your answer is, it's really a nice discovery, but unfortunately, it is not patentable because it is already existing in the world. So it is not patentable, but definitely it's a discovery. So many a time scientists may feel that whatever they discover, that is a new patent, but it is not as per the section 3C. Section 3D, efficacy or new use. Efficacy. And here we are talking about therapeutic efficacy. What do you mean by therapeutic efficacy? Let's take an example of the pharmaceutical product. Suppose a medicine is experimented in a laboratory on a group of 100 people ranging from the age 25 to 30. And out of this 100%, 70% cure from the disease. So the laboratory suggests that the efficacy is 70%. But therapeutic efficacy suggests that when that particular medicine is applied to the real world, suppose to the 1,000 person of a real world, and if only 500 persons are cured through that medicine, then the therapeutic efficacy is only 50%. So if the therapeutic efficacy of any drug is not increased, then that drug is not at all patentable or it is not considered as an invention. Or any new use of a known thing. Suppose a medicine is known for the headache problem, and now someone else is also defining the same medicine is it can be used for the stomach pain as well. So it's a mere new use of a known thing. That's why it is not at all an invention. Next is mere admixture. Now, what do you mean by mere admixture? Suppose medicine A is for headache and medicine B is for stomach pain. And if you are deriving any medicine C which solves the purpose of headache and stomach pain, then it is not an invention because it's a mere addition of a medicine which can solve headache problem and stomach pain. But if the same patent is providing any synergetic effect, it means when we are adding an headache tablet with the stomach pain tablet and it shows it is used to cure any cancer cell. So that is the synergetic effect, which is not defined previously or not defined by the combination of two things. So if such thing is happen, then it is patentable. Next, mere rearrangement. Suppose one person having one umbrella, and now that person, what he did, he has provided a fan inside the umbrella. Now he is suggesting, as no one having such kind of idea in the umbrella with a fan, so please give me a patent of it. Whether it is patentable? No, it is not. Why? As per section 3F, what it suggests? It's a mere rearrangement. Means everyone is knowing umbrella, everyone is knowing fan. It's just a rearrangement of two different things, which is very common or very known, very well known. So that's why it is not at all an invention. G is omitted. H is for agriculture or horticulture. Any method of cultivation through agriculture or any horticulture method is not comes under the Patent Act. It is comes under the PPVP, Plant Variety Protection Act. PVPT, like something like that. Plant Variety Protection Act. So it is not comes under the IPR rights of patent, but it is preserved under the different rights. So that is defined under ground H. I ground is interesting one, which defines, here I have written Superman, Spider-Man. Why? Because what it suggests, I ground suggests that any method of treatment, like a surgery of open heart surgery or something like that, so that process is not patentable. The method of treatment is not patentable. It's not an invention. But yes, the instrument with which that process is carried out, process of treatment is carried out, method of treatment is carried out, that instrument is patentable if it is unique. J for jungle, plants and animal. Like we have already discussed in H ground, the cultivation is not at all an invention. Here also, if new variety of plant or new variety of a new breed of animals are there, so that is also not at all an invention. But yes, if the lab grown microorganisms are there, lab grown microorganisms, that particular microorganisms are comes under the invention and it is patentable. K, K suggests that the mathematical modeling or any algorithm or computer programming or business model, these are not an invention. So in order to remember, one can remember K with the computer. So computer programmings are not at all an invention as per section 3K. 3L, copyrights, any literary work or any kind of poetry, any design, any drawing, a beautiful sketch, any art form, cinematography, music. These are not at all an invention, but it can be protected under copyright. Subground M talks about method of playing game, mental act. You are knowing one famous name of Swanisa, who is a mentalist and giving her souls in every part of an India. So it's a mentalist. Suppose Swanisa come to you and says, I would like to file a patent on my mentalist activity. So it is not patentable because it's come under the section 3M. It's a mental act. It is not patentable. 3N presentation. In many a time, while doing master degree or PhD, the project we are come under or we are taking, that project is not, while we are discussing that project through the presentation, then it is not called as an invention. Until and unless you have not prepared it, you have not formulated it, fabricated it, and not done research experiment on it and derive certain uh, practical output, till that time it is just a presentation, and that presentation didn't consider under the invention. Oh, topography. Topography of semiconductor is also protected under a different set of IPR, but not under the Patent Act. And T, TKDL, Traditional Knowledge Digital Library. So whatever traditional knowledge that we are having, that our ancestors are knowing, if someone is coming out with that particular medicine, which is already known in India, in Ayurveda or any Purans, so that is not at all patentable as per 3P. So have a look here, prepare a notes, go through each and every ground and try to recall it from A to P and P to A in both the manner. Following section has to be remembered with the subgrounds. Which are those? Section 3, Section 25, Section 64, and Section 90. Apart from this, if other sections are not known with the subgrounds into it, it's okay. But following sections has to be known with each and every subground of it. Now, what about section 4 and 5? Section 5 is omitted, and section 4 talks about the any invention which is related to atomic energy as per the Atomic Energy Act 1964, it is not considered as an invention. Now let's come to the section 6 part. So section 6 talks about person entitled to apply for a patent. There are only three persons, those who are entitled to file application for a patent in India. Which are those? The first one is true and first inventor. The second one is assignee. And the third one is legal representative. The legal representative is mentioned under 2(1)(y). The assignee is mentioned under 2(1)(ab). And the true and first inventor mentioned under 2(1)(k). Either alone or jointly, they can file a patent application in India. And also with the section 6, one can take a reference of section number 134. Section 134 talks about who cannot file an application in India or who cannot have interest in any of the application in India. Those who are from the non-reciprocating countries. If a person from a non-reciprocating reciprocity country, non-reciprocity means India is providing a citizenship kind of privilege to that country person, but in that country, if some Indian is filing an application of patent, so Indian is not getting the same kind of treatment, then it is called non-reciprocity. And if that country is not providing privilege to the Indian person, so India is also not going to provide any kind of privilege to that country as well. That is called reciprocity. And as per section 134, it defines which are those countries which not providing the same kind of treatment to Indian citizen, and basically it is non-reciprocating countries. So any person from that country will not have any rights of any patent filed in India. Let's talk about section 7. Section 7 talks about form of application. The first point here it is one application, one patent application is for one invention only. Not more than one invention can be derived in the one application. The second point is proof of right. Now, what do we mean by proof of right? Let's you are the owner of a pharmaceutical industry, and I'm applying for a post of an employee under your ownership. So you are giving me one offer letter in which clearly it is mentioned that whatever invention coming out from this company that belongs to you, it means to the owner of that company. So that offer letter itself considered as a proof of right. And while filing any application, such kind of proof of right has to be provided within 6 months from date of filing of that application as per rule number 10. As per rule number 10, the proof of right has to be submitted within 6 months from filing an application of patent. Suppose if you want to file patent application outside India, so there are two ways. One is conventional route, another one is PCT route. Conventional route means first you file application in India, and then within 12 months you are filing an application in any convention country. That is called conventional route. Now the second route, which is mentioned here, it is PCT, through Patent Cooperation Treaty. What it suggests? Let's define. Rule number 18 defines that if any application from any convention countries came to India, or any Indian person wants to file an application outside India, in both the manner, the dealing has to be done through the Delhi Patent Office. So Delhi Patent Office is the receiving office. Now what will happen when a person filing an application from India to outside? It is converted into three copies, which are those: home copy, record copy, and search copy. The home copy is kept held in the Delhi office only. The record copy is sent to the International Bureau at Geneva, and the search copy is submitted to the International Searching Authority. As per rule number 19, the Indian application can be filed in Hindi or in English. But if any application coming from outside country to the India, then it has to file an application in English only. Rule number 19C talks about international search report. So once we are submitting international search copy, we required international search report from the International Searching Authority. So when that international search report will be provided, that international search report will be provided with two conditions. The first condition is 9 months from the date of priority or 3 months from the submission of international search copy, whichever expires later. Let's take an example, case number one, in which I'm filing an application in India today, or let's suppose on 1/1/26. I'm filing PCT application or international application, or I'm filing international search copy within 12 months, correct? So by 1/11/26. So now, when will I get international search copy? So international search copy says that 9 months from the priority, what it is, 9 months from here, priority. Priority means first time when you are filing an application in India. So it is 9 months from here, 1/10/26, and 3 months from the international search copy submission. That is 1/2/27. Whichever expires later. So which expires later? This one, correct? So that's why within this date, you will get international search copy. Now, for you as an homework, there is one question. Suppose that this date would be 1/3/26 instead of 1/1/26. If it is 1/3/26, what would be the date at which I should get the international search report? Note it down and then first find out the answer of it. If you are not getting the answer, just WhatsApp me or call me out so that I can explain it in a better manner to you. And if you are able to find out the answer, then proceed further. Give me the answer in the WhatsApp so that I can check it out and give you the reply whether it is correct or not. PCT timeline. PCT timeline suggests suppose today we are filing up an application in India. So within 12 months, we need to file international application. Within 16 months, so 12 plus 3 is 15. So once the 16 month is commenced, we will get the international search report in our hand. The publication will be held within 18 months. Sorry, once the 18 months is completed, the application will get published automatically. Within 22 months, one can opt for the international preliminary examination. It's an option. So one can opt, one cannot. There is no compulsion on it. And within 30 to 31 months, one can file an application or one can enter into the national phase of any other country for filing an application. Section 8, information and undertaking regarding foreign application. Section 8 needs to be learned with rule number 12. What it talks about? It talks about form number 3. Now, form number 3 talks about what? Form number 3 talks about when you are filing an application in India, at that time, if you are planned to file an application outside India, or if you have already filed an application outside India, so that information has to be submitted through form number 3. So rule number 12 suggests once you are filing an application in India, so from the filing date, within 6 months, you have to file form number 3. Suppose you are not going to file application outside India. Once you are filing an Indian patent application, then also within 6 months you need to file form number 3. which is having 0 rupees of fees. And why it is required? If you are not filing application outside India, then you need to give such kind of statement that I am not going to file any application outside India. Correct? So that is also required. Next thing is, once it is asked in the first statement of objection or first examination report, suppose in the first examination report, it is asked that please furnish the detail of form number 3. So once it is asked in the first statement of objection, which is also called as in first examination report, then from such demand, within 3 months, you need to furnish the information of form number 3. And suppose in between, anytime, controller demands for the form number 3 requirement, then within 2 months, one need to file form number 3 from the controller's demand. And this 3 timeline can be extended to further 3 months by filing form number 4 with it. So that's it from the section 8. Section 8 talks about the timeline of the form number 3, and rule number 12 defines within which time it has to be filed. Now, section 9. Section 9 talks about provisional and complete specification. So, if you are planning to file an PCT application or convention application, then you are not allowed to file it with the provisional application. So, PCT application and convention application can be proceeded with only complete specification. So now what's provisional specification? Provisional specification, it means you are providing a certain information like title, abstract, and claim part of it, so that you can file a provisional application once any idea strikes in your mind. And complete specification means the complete application which having following points, starting with the title, then field of invention, then uh, background, objectives, summary, brief description, detailed description, claims, and abstract. So if an application is incorporated with following details, then it is called complete specification. If it is only providing title, abstract, or any one of the claim, then it is called provisional application. Suppose any application is filed with the provisional specification, then that application has to be completed within 12 months. It means one should file a complete specification within 12 months. If it is not filed, then that particular application is treated abandoned. Now, suppose if one person is filing more than one provisional application for the same invention, so the priority of the first provisional specification will be treated as a priority date of the application. Example, suppose provisional specification 1 filed on 1/1/26 and provisional specification 2 filed on 1/1/28. Sorry, not 28. I should take 26 because within 12 months one need to file it in a specification complete. So 1/4/26. And after this, with this two application, merging these two application, if you are filing complete specification on 1/1/27, then the priority date of all this application whether it is complete specification, provisional 2, or provisional 1, the priority date of that application remains the priority date of the first application. Next point. If any complete specification is filed directly on the first date, suppose any complete specification is filed on 1/1/26, then within 12 months, so till 12 months, it can be treated as provisional specification within 12 months. Next, the date of filing can be one can be post dated for the 6 month. So suppose an application has to be filed on the provisional specification is filed on 1/1/26, and it is converted into complete specification by 1/1/27. It has to be converted because within 12 months it has to be filed complete specification. Suppose we are not able to cope up with this timeline and we require extension of time. So I can file this complete specification by 1/7/27. So what I should do, I would request to the controller to post date my provisional up to 6 months. So up to which date it can be post dated? It is post dated till 1/7/26. So what will happen now? The priority date of this provisional specification is become 1/7/26, not the 1/1/26, because it is post dated. So one can lose the priority, but definitely yes, one can extend the time to file provisional specification to complete specification. Now let's talk about content of specification. The content of specification 10.1 defines, as per rule number 13, the title of any invention must be within 15 words, an abstract within 150 words. As per rule 15, any drawing sheet must accompany the following points. It should be in a A4 size paper. The applicant name has to be mentioned at the top left corner. The seat number has to be mentioned at the right top corner, and the signature has to be mentioned at the bottom right corner. Also, the margin at left and top is 4 centimeter, and bottom and right that should be 3 centimeter margin. And as per rule number 16, see, the actual model is not a part of the specification, but it doesn't mean that you are not preparing the actual model. Controller can ask any time to show that actual model. And once the controller demands, within 2 months, you need to show that particular model to the controller as per rule number 16. Next part is, as I've already mentioned, the complete specification must be accompanied with title, preamble, field of invention, background, objectives, summary, brief description, detailed description, advantages, claim, and abstract. It also shows the best method to perform for that invention. That's it. And also, if any application contains any biological material, that biological material has to be deposited into the International Depository Authority, deposit on or before filing an application in India. Let me write it down. The biological material. If your application contains any biological material, that material has to be deposited on or before filing. Correct? The reference of it has to be filed within 3 months from date of filing. And if form number 9 is filed, which is for the early publication, form number 9 is for what purpose? Early publication. So if form number 9 is filed, then the reference of the biological material has to be furnished on or before filing form 9. Next thing is, if one is filing form number 5, form number 5 is for mention of inventorship. Mention of inventorship. So an applicant can be a different person, or owner can be a different than the inventor. But the credit has to be given to the inventor, and that can be given by filing form number 5. So form number 5 has to be furnished with the complete specification. If it is not furnished, then 1 month of extension can be filed by filing form number 4. And with that 1 month of extension, the form number 5 can be filed either with complete specification or within 1 month from complete specification. Next thing is the claim or claim of the complete specification shall rebates to and single invention. The claims has to rebates to or relates to and single invention, or a group of invention linked to a single inventive concept. Suppose you are filing an application for a petrol tank. You are filing an application uh, for the engine. Then engine can be treated as one of as a separate invention. Fuel tank can be treated as a separate invention, but a fuel tank, a silencer, engine, tire mechanism, the chain mechanism, the whole thing is linked to a single inventive concept which is called bike. That's why it is also possible to file an application which is targeting to a single inventive concept. That's it. This point is already covered, and this point is also covered. So this is about section 10. Now let's talk about section 11, the last section of today's session. Section 11 talks about priority date of claim. So far, we have known the priority date of application, which is the first filing date of the application. Now, what do you mean by the priority date of claim? In order to understand this section, there is one tagline. The priority date of claim is the date at which the claim is disclosed first time completely. Now let's take an example. A provisional application or complete application, complete specification has been filed on so and so date, and it is completed within 12 months into complete specification. Now let's see the date. The provisional specification filed with claim 1 only on 1/1/2021, and complete specification is filed with claim 1 and claim 2 on 1/1/2022. So now the priority date of the claim 1 is 1/1/2021 because it is completely described on 1/1/2021. But the priority date of claim 2 is 1/1/2022 because it is completely described on 1/1/2022. In the similar manner, suppose we are having three provisional specification, one with claim 1 on 1/1/2021, with claim 2 on 2/2/2021, and with claim 3 on 3/3/2021. And suppose this three provisional specification combined together to form one a complete specification, then the priority date of the claim is the priority date of each and every application published with each and every claim into it. Means the priority date of claim 1 is the priority date of provisional specification 1. The priority date of claim 2 is 2/2/2021. The priority date of claim 3 is 3/3/2021 because it is completely disclosed on so and so date. But the priority date of application is 1/1/2021, even for the provisional 2 and provisional 3. So there is a difference between priority date of application and priority date of claim. I hope that difference is clear in your mind. And suppose we are post dating this application, suppose we are post dating this application, then what will happen? Just apply your mind and tell me the answer in the WhatsApp. So once completing these two assignments, I have submitted two assignments to you in this session. So complete those assignments, and also I will provide you with a certain number of questions, 50, 60 MCQs. Attempt it and boost your energy. I hope this session will help you to understand the Patent Act in a simple manner. If you are having any doubt, I would like to answer your questions. Have a nice day. Jaivir Shah signing off. Jai Hind.